Hi, I'm Keith Davidson of Albertson and Davidson, and today I want to talk to you about overturning a trust or will based on fraud. Now, when you have a trust or will that you want to overturn, there's a number of different grounds that you can use. Lack of capacity, undue influence, those are the two that are used the most. But there's a third one that isn't used quite as often, and that's based on fraud. And the idea of fraud is that somebody obtained that will or trust by essentially lying to the testator, lying to the decedent, and making them create a will or trust that they wouldn't have done had it not been for that lie. Now, most of the time it's hard to prove a fraud claim just because the people who committed the fraud won't tell you what it is they said, and nobody else was around to hear it. So a lot of times fraud has to be proven by circumstantial evidence. That means you have to go and find the situation. You have to find people who may have heard conversations before or after the fraud. You have to find anything that would lead you to believe that the will or trust was changed, not because that's what the decedent wanted, but because they were lied to. And so, for example, maybe their past wills and trusts gave everything to their children, but then after the fraud, everything goes to this wrongdoer. And so you have to go through all of that evidence and try to build that case for fraud. But if you have that evidence, and if you can find those type of circumstances out there, then you may just be able to set aside a will or trust based on a fraud claim.